Secretaries of KMU, of Kilusang Mayo Honor KMU, Ms. Imelda de la Cruz, and Mr. Roel Sabado of the Philippine Government Employees Association. Also in attendance is a representative of the management or employer sector, Mr. Virginia Ayala of the Bankers Association of the Philippines. That will be all, Your Honor. Thank you po. Ma'am Arlene Rosas of Gabriela, Party List Gabriela. Yeah,
Thank you. Thank you, Committee Secretary. Our first item on the agenda is discussion on House Bill 7043, strengthening the right to strike. We would like to acknowledge our Deputy Speaker, Raymond Mendoza, for his sponsorship speech.
Well, with the sponsorship speech, Mr. Chair, will be attached to the record. Can we go straight to the what we intend to amend under 260, Mr. Chair? Is it possible?
Yes, Deputy Speaker, the manifestation is hereby approved.
Under section 3, Mr. Chair, this is letter G, and in line with the national concern for this purpose, the contending parties are strictly enjoined to comply with such orders, prohibitions, injunctions as are issued by Secretary of Labor and Employment or the Commission under pain of immediate disciplinary action, except dismissal. Ito lang, Mr. Chair, I'd like to introduce, except dismissal or loss of employment status, including, and that's it, Mr. Chair, for section 3. Mr. Chair.
Thank you, Deputy Speaker. Can we hear first from our representatives from the Department of Labor regarding the proposed amendment on Section 3? Attorney Ramon Saura, Bureau of Labor Relations.
Good morning, Mr. Chair. Apologies, I don't have the one that we reviewed will be the amendments on 263, G, 264A, and 272.
Section 3 refers to removing dismissal or loss of employment status. Can we hear the Department of Labor's stand on the proposed amendments?
Your Honor, if we refer to the knowingly participation in the legal strike and knowingly participation in committing the illegal acts, Your Honor. At the moment, we have only some initial thoughts on this. The Bureau has not made a definite position. But if in that connection, Your Honor, our initial thoughts on this would be that in knowingly participating in illegal strike, union officers have the duty, if I may, the rationale why there is an automatic considering the dismissal of the one who knowingly participates in an illegal strike for union officers would be that union officers have the duty to guide their members to respect the law. If instead of doing so, the officers urge the members to violate the law and defy the duly constituted authorities. The dismissal from the service is a just penalty or sanction for their unlawful act as held by the Supreme Court. As officers of the union, they are tasked with a duty to lead and guide the membership in decision-making on union activities in accordance with law, government rules and regulations, and established labor practices. The leaders are expected to recommend actions that are arrived at with circumspection and contemplation, and always to keep paramount the best interests of the members and the union within the bounds of law. If the implementation of an illegal strike is the one he recommended and adopted, then they would be misleading and deceiving the union membership, and consequently, the supreme penalty of dismissal is appropriate to be meted on them. The commission of illegal acts in the course of a strike would make it illegal, and the striker involved therein, irrespective of whether he is a union officer or an ordinary member, will suffer the penalty also of dismissal. Under the labor code naman po, even if there is anyway po, the remedy is available always to file for an action for illegal dismissal before the National Labor Relations Commission. And a relief from that action, if found to be illegally dismissed, then the striker will be reinstated without loss of seniority rights, Mr. Chair.
Thank you. So the initial finding of the Department of Labor is you agree with the proposed amendment because there is a provision in the law already on illegal dismissal.
Your Honor, the Supreme Court reasoned that making the penalty of dismissal is reasonable in cases of knowingly participation in illegal strike and knowingly participation in the commission of illegal acts in a strike.
That is the opinion of Dole. That's why they're called Department of Labor and Employment. So, will you agree with me that even the statutory instructions are always in favor for downtrodden and of course, the manggagawa, the interpreting laws of the labor code? That being said, Mr. Chair, what I'd like to say to the attorney from Dole is that the ILO disagrees. In fact, in the high-level tripartite mission in 2009, specifically said that we stated no, we should preserve employment, however it may be. But then again, we will not turn a blind eye on ano ang ginagawa nila. Instead of dismissal or loss of employment as penalty in this bill, we are proposing that the erring employee would subjected to disciplinary action, but in no case shall be an action to be loss of his employment status. The rationale is that dismissal or loss of employment is a penalty that is too far statutory draconian and is not commensurate with the violation committed. Again, this is in line with the ILO, International Labour Organization's statement in the high-level tripartite mission way back in 2009, Mr. Chair. And of course, if I may, Mr. Chair, he read the whole statement from Dole, considering also under letter A of Article 264. Mr. Chair, can I just this after it is in line is what being said in letter G, where any worker whose employment has been terminated as a consequence of any unlawful lockout shall be entitled to reinstatement with full back wages for the time. Mere participation of a worker or a union officer in a strike, ito ang palagay namin ilagay dapat, na mere participation of a worker or a union officer in a strike declared illegal for failure of the union to comply with procedural requirements. Again, procedural requirements under paragraph A of this article shall not be a ground for termination of his or her employment, even if a replacement had been hired by the employer during such illegal strike. And it went on, it goes on, any worker or union officer who knowingly participates in the commission of illegal acts during a strike, yun ang concern mo, Tanero, shall be subjected to due process under the jurisdiction of the regular courts over any criminal action, of course, penal code, arising from the violation of any of the provisions of Article 264 of the Labor Code as amended, but subject to the required clearance from DOLE, of the Department of Labor and Employment, on cases arising out or related to a labor dispute. Mr. Chair.
Mr. Chair? It seems that I don't have a copy of the amended bill already, because what I have here is the original House Bill 7043 of Congressman Mendoza. But in any case, I would like to, so this is the one. You know, we want order in all the things that we do in our country, especially so in this particular case. Kasi kung alam niya, nakalagay naman dito, any union officer who knowingly participates in an illegal strike, and any worker or union officer who knowingly participates in the commission of illegal acts during a strike may be, nakalagay, under our existing law, may be declared to have lost his employment status. And I assume that when this is provided here, there is due process also here, procedural due process. That before the person is terminated, there will be due process where first it should be established that he knowingly participated in the legal strike and at the same time knowingly participates in the commission of illegal acts. So ito yung maximum penalty actually dito. So kailangan i-prove muna whoever will file the complaint that there indeed was the commission of an illegal acts of the individual, and the commission is actually parang he knows already that it's an illegal act and yet he still commits the same act. So I think kung lalagay lang natin under pain of immediate disciplinary action, walang-wala, very vague yung disciplinary action. Anong ibig sabihin nun? Hindi maliwanag. So, I assume that the existing provision is enough to, anyway, there is due process that will be followed. Procedural and substantive due process are stated in this particular existing provision of Article 264 of the Labor Code, Mr. Chair.
Mr. Chair. That's why the sentence of great Congressman Go stated procedural and substantive. This is where we, when you say procedural, example, may problema lang sa NOS, notice of strike, pulling off period. And of course, the strike vote, ito po lang from dyan. Because of a procedural requirement na hindi na-comply, tanggal sa trabaho yung isang empleyado, hindi naman. But of course, when I stated here that substantive violations will require also, and it must be proved in regular, again, in the jurisdiction of regular courts for criminal action, and then again, that will be under the penal code, but must have respect to the clearance from DOLE on cases arising from such actions, Mr. Chair. I hope Congressman Go will see the light, considering that this has been a subject of much discussion in Geneva, where he regularly attends. It's actually part of the report in the high-level HTML, which is the high-level tripartite mission in, again, 2009. Mr. Chair.
Thank you, Deputy Speaker. Can we have the opinion of DOLE regarding the report of the ILO on the harsh penalty rule being implemented on dismissed employees? Does the comment does the comment of ILO, does it hold any value here in our Philippine laws?
Mr. Chair, 2009, baka si Atty. Kung nandun na ako, Mr. Chair, by the way, I've been attending ILO since 2000. This is my 24th year, 22nd year. Mr. Chair, I was there. Congressman was not there, so he can't comment.
Yeah, I was not there, I'm sorry. But, you know, when somebody knowingly participates in an illegal act, and at the same time also knowingly participates in the commission of illegal acts, talagang parang alam niya na bawal yon, illegal yon, at gagawin niya, bibigay mo lang ng parang pinalo mo lang sa kamay, palagay ko, it might open the Pandora's box. Baka magiging walang visa itong mga ano natin, di ba? Yun naman siguro. Ang importante lang dito sa tingin ko, the procedural and substantive requirements are complied before the imposition of the penalty of termination or loss of employment of the individual employee or union officer. Yun lang talagay ko ang pinaka-importante rito. And we want to be sure that effort should be done before imposing the penalty of termination on the part of the management or the employer to the employee or union officer.
Mr. Chair.
Yes?
Thank you, Mr. Chair. Mr. Chair, yung bill kasi is, the proposed bill, yung House Bill 7043, it is seeking to strengthen the workers' right to strike and will fortify our commitment to uphold the workers' constitutional right. Kaya yung removing the clause on harsh retaliatory actions on illegal strike and simplifying the conduct of strike in case of union busting, nagpo-propose po kami dito ng complementary amendments din. Actually, sinulat naman po namin yun kay DS, no? Sa proposal po namin, we would like to clarify the imposition of disciplinary action to exclude termination or loss of employment, so as not to defeat the purpose and intent of the measure. Sabi nga, it has been well argued that the loss of workers' livelihood severely affects not just the worker, but his or her family as well. Removing it as penalty, however, is not intended to prejudice or discount the company prerogative to impose sanctions, nor to condone any unlawful act. So, Mr. Chair, mas leaning on the position of ES Mendoza tayo, na napaka-harsh naman kung tatanggalan mo kagad ng trabaho yung manggagawa. And specifically, Mr. Chair, narito po si Mr. Joselito Ostares, baka pwede po siya bilang manggagawa, pwede po siyang magsabi kung ano yung nangyayari sa ground, Mr. Chair.
Mr. Chair, ito lang. Kung ang magagawa, kung medyo malilego, tanggal, yung penalty, so that's why it imposes tanggal termination sa trabaho. But what is yung kapitalista, yung management, and they sometimes knowingly violate, and they always do that. Bayad lang sila 10,000 to 100,000 pesos. Kami, hanggang sa trabaho. Sila, patuloy. Kano lang yung 10,000, 100,000. Sabihin lang yan sa corporate funds. Diba? So, that's why I am saying that it is actually swayed against. So that is why the level of the playing field, again, fully noted na substantive procedure, substantive violations should be dealt with accordingly, and we have been opposed to that. Thank you, Mr. Chair.
Thank you, Deputy Speaker. Can we hear from Mr. Lito Gustales, KMU, regarding the perspective of the manggagawa on the harsh penalty?
Magandang umaga po, Mr. Chairs. Maraming salamat at nabigyan ng pagkakataon ng mga manggagawa na lumahok dito sa discussion. Masarap kong pakinggan yung title, na strengthening the workers' right to strike. Sarap pakinggan. Parang napakalaya ng mga manggagawa para magwelga, para mag-strike. Pero sa totoo lang po sa ground, marami pong exit na nagiging sagabal doon sa mga aksyon ng mga manggagawa sa grounds. Unang-una po, meron pong dalawang nagpapahirap din sa mga manggagawa. Tama yun, yung binanggit na kanina na dapat yung mga manggagawa ay hindi basta-basta tinatanggal. Pero sa grounds po, ang nangyayari, meron pong dalawang klase ng pagpapail ng strike. Halimbawa sa CBA deadlock, pwede pong mag-file ng strike ang manggagawa. Ganun din po sa ULP, pagka merong ULP ginawa. Kaya lang po, yung tagal, doon sa tagal ng time na merong cooling off period, halimbawa CBA deadlock, merong cooling off period na 30 days, wherein sa ULP or unfair labor practice ay merong 15 days na cooling off period. Dito po sa mga panahong ito ay nangyayari yung mga attacks ng management sa union, sa mga manggagawa. Kung minsan po, hindi pa nakapagpapile ng notice of strike yung mga manggagawa, tinatanggal na. So, tinatanggal na sa kumpanya. Karamihan pong tinatamaan dito yung mga opisyalis ng union halimbawa, kapag ka nag-file ng NOS, yung isang union, meron pong 30 days na cooling off period. Nagpapatawag ang NCMP niya ng conciliation, tinatatawag yung management and union, and then during the conciliation, mas madalas pong nangyayari na nagiging karanasan namin, sa unang-unang conciliation meeting pa lang ay nagpapile na yung management ng assumption of jurisdiction. So kasabay po nun, unang-unang hearing pa lang ng ipinatawag ng management ng DOLE, ng NCMB. Meron na siyang ipinapile. Ang management ay nagpapile na ng assumption of jurisdiction. Kasabay po nun yung pagpapile din niya ng lockout sa kumpanya. So, ano po yung gagawin ng mga manggagawa sa panahong yan? Wala siyang leeway, wala siyang pwedeng ikutan. So ano yung gagawin niya? Maggagawa po siya ng mga mass action o sama-samang pagkilos, magkakaroon ng mga general membership assembly, magkakaroon ng mga meeting yung mga manggagawa. Pero sa panahong yan, dahil sabi nga natin ay merong cooling off period, hindi niya magawa yung karapatan niya na dapat sana ay magawa niya sa panahon yan. Kaya pagka nag-file na ng assumption of jurisdiction, yung management, nandiyan na kagad yung mga restriction. Hindi ka na pwedeng gumawa ng mga action, ng mga sama-samang pagkilos, hindi ka na pwedeng gumawa. Dahil ang gagawin niyan, ng management yan, magpapile na siya ng illegal concerted action. Yun na yung magiging kasunod. At sa kadalasan po namin, meron pong decision ng ang Supreme Court sa illegal concerted action na ang sabi niya ay illegal yung strike. So, saan pa pupunta yung mga manggagawa? So, napakahaba po dito sa panahong ito, napakahaba ng proseso. Gusto ko lang po i-cite yung siguro pinakahuli. Isa-cite ko lang po yung nangyari sa Hacienda Luisita. Meron din po yung bagamat iba yung forum sigurong pag-usapan yung assumption of jurisdiction, pero yan po yung ginamit ng management to sa Hacienda Luisita. Tapos saan ay meron naman na siyam, maraming sugatan, no? At talagang yung strike mismo, dineclare na illegal. So, saan pa pupunta yung mga manggagawa? Nasaan yung kanyang binabanggit nating right to strike, yung karapatan ng mga manggagawang magwelga? Kaya sa amin po, napakahirap. Nung gano'n, yung illegal, yung ULP, pagka sinabing ULP, lahat ng opisyalis tanggal. So, may mga kaso na yan. Ano gagawin ng mga manggagawa? Kung tinanggal na yung mga opisyalis, di magwewelga. Talagang ganun yung direksyon eh. Yan talaga yung magiging isip na ng ano eh. Ano? Magiging nasa kumbaga instinct ng mga manggagawa na ipagtanggol yung kanilang karapatan sa pamamagitan ng samsamang pagkilos o wega. Kaya yun po, yung isang napakahirap na sitwasyon, napakahirap na kondisyon sa mga manggagawa sa grounds.
Salamat po. Salamat. Can we also hear from the management, ECO, represented by Mr. Robert Maronilla?
Good morning, Mr. Chairman. Good morning po sa lahat ng members ng committee. Good morning po sa lahat. Yeah, thank you, Mr. Chairman. First of all, I would like to manifest we will be submitting a position paper because I just read the amended version today. And Mr. Chairman, reading the explanatory note of Honorable Mendoza, the high-level mission is mentioned here. I would like to note lang po that Convention 87, which talks about the freedom of association, does not contain any provision whose ordinary or literal meaning would imply the existence of a right to strike. Matagal na pong pinagdidebate ito ng employers at ng labor, meaning po, for the employers group worldwide, the right to strike is not included under Convention 87. For the workers group po worldwide po, the right to strike is included under Convention 87. So I would just like to note that dun po sa, according to the ILO, wala pa silang final decision on this. So based on the employer side, the right to strike is not included under Convention 87, which is the right to organize. Second po, Mr. Chair, yung sinasabi po natin na too harsh of a penalty, if we think of things in a general sense, I think the purpose of the law, that's why po too harsh ito ay because the entire business is at risk. Kapag nag-strike po, yung buong kumpanya po is affected, not just management but also labor. So yun lang po ang purpose niyan. I fully support the position of Honorable Go that there are safeguards already in place. Existing laws already are there, and as long as procedural and substantial due process is followed, I don't think there will be a problem with that. Yeah, in summary po, Mr. Chairman, I would just like to share with you the position of the Employers Confederation of the Philippines that we are not inclined to support the bill in its entirety. Kindly wait for a position paper because there are new amendments. Yun lang po. Thank you. Thank you very much.
Mr. Chair, is it possible for TUCP, our spokesperson is here?
Yes. Can we hear from Mr. Louis Corral?
Thank you, Honorable Chair. Two things. With respect to the right to strike, which is a constitutional right, and with respect to cooling off period. With respect to the right of the strike, you cannot implement fully the spirit and intent of ILO Conventions 87 and 98, the right to organize and the right to collectively bargain without the economic right of workers to peaceably express grievances, including the right to strike. And that is constitutionally protected. On the matter of assumption of jurisdiction, that forms a package of reform measures that the high-level tripartite mission has recommended for the Philippines, in which the UCP has discussed with both the Speaker of the House and the Majority Floor Leader, with the Deputy Speaker. And there is this sense that we have to move away from the aversion of the last 6 years from human rights and labor rights simply because previous thinking of the powers that be were that these were Western oriented. We have common values. We have common ideas of what is right and wrong. And that's where this proceeds from. On the matter of the cooling off period, we do have fundamental difference from the position of KMU. The position of the UCP is the cooling off period should apply to collective bargaining disagreements and deadlocks and unfair labor practices. It is only in instances where unfair labor practice constitutes union busting where the cooling off period should not apply. Yung tatanggalin yung mga opisyal ng union o talagang widespread at flagrant yung violation of labor rights. So, the cooling off period is now fundamental because of the nature of our labor market and employment market. We don't have large manufacturing firms anymore because of the power costs. We have essentially a service sector. And the service sector employer would just laugh at us and say, okay, let's make it easier for strikes to happen. So, hayaan natin sila mag-picket dun sa labas, lilipat dun tayo. That's the reality. So it is very needed at this point of time, where labor density is now down to 5%, for the Department of Labor and Employment to step up and intervene through mediation and conciliation to save not just the business, but more importantly, to save jobs. That is the harsh reality of our labor market. So the right to strike, while fundamental and uncontestable, should be exercised within parameters that provide for decent work. So the package of amendments, Your Honors, that have been proposed to the Speaker, including limiting assumption of jurisdiction only to matters that refer to essential industries as listed down by the International Labor Organization, and not national interest, which is too broad and too wide in its application, such that even a match factory or a factory producing slippers or underwear could be placed under ambit of national interest. So what we are really doing is revising our labor code to conform with both the needs to balance the interests of labor and the interests of management at a time when labor strength is at a decline, when widespread contractualization and ENDO makes it impossible for workers to organize because of corporate impunity and fear of the bosses, when there is also the presence, unsaid, unspoken, of state impunity. That's why even the NPR-ELCA is trying to camouflage and deodorize itself by calling itself the National Task Force for National Unity, Peace and Development. So, that is the context. Now, having said that, what is the international trade implication and employment market implication? Well, both the U.S. government, we were fortunate enough with the Deputy Speaker to meet with the National Security Advisor of the U.S. last December, and the U.S. Trade Ambassador, Catherine Tai. So we met with Jake Sullivan and Catherine Tai, and under the current U.S. global labor policy, there is this worker-centered focus on trade. And that is the reason for negotiations on the Indo-Pacific Economic Framework right now. That is the consideration for the possible reauthorization by the U.S. Congress of the U.S. GSP. That is the reason, incidentally, for the extension by 2 years of the EU GSP. That translates to 6,500 product lines, which now can enter the United States and Europe tariff-free. That translates, of course, to hundreds of thousands of possible decent unionizable jobs. Having said that, there's one last point. Last Friday, the Deputy Speaker and I met with Alice Albright of the Millennium Challenge Corporation. They skipped the last 6 years because they said, well, we don't see human rights. Now they're back in business with the Philippines. They're looking at a small grant component of $30 million, a threshold grant. But beyond that, they're looking at an $800 million grant, a compact grant, similar to what they gave in 2014 for Kalaki Seeds, for building roads in Lake Sabah. So the pivot of President Marcos to a worker-centered trade regime, I think is what we should take a look at, because it is now consistent with international trade practices, outside, of course, of the model of China. So with that, Your Honors, we hope that this bill, with the recommendations of the Deputy Speaker, will be adopted by the committee.
Thank you very much, Mr. Ruby Coral. Can we hear from NCMP?
Thank you very much, Honorable Chairperson and the Deputy Speaker and sponsor of the bill. The NCMB at the outset would like to reiterate our support for the workers' constitutional right to participate in the right to participate in self-organization and peaceful concerted action. So supportive po kami po. With regard to the removal po ng penalty of dismissal or loss of employment status as a penalty for violation of orders, prohibitions, or injunctions issued by the Secretary of Labor, we would like to propose that it be revisited. We acknowledge po na yung current provision is placed in the labor code to caution our union officers and members to only employ means that are lawful to attain their legitimate objectives. So, kagaya po ng sinabi ni Honorable Go, na yung mga systems natin are in place naman po to ensure na yung mapaparusahan lang talaga ng dismissal ay yung nag-commit ng crimes. Yung mere participation, hindi naman po. So, tinitignan po naman ng pagkakataon yung mga ganong kalapisan. So, yun lang po talagang nagmalabis. Yun lang po siguro ang dapat maparusahan ng penalty of dismissal and loss of employment status. Regarding naman po dun sa cooling off period, we agree with Sir Louis Coral na dapat i-preserve po yung cooling off period dahil yun po yung pagkakataon ng NCMB na mag-usap at maghanap ng solusyon para saan man pong disputes. So, kung aalisin po yun, ay magkikipit tayo sa paghahanap ng paraan para po ma-resolve ang isang issue or dispute. So, balit, pagka nagkaroon naman po ng union busting, kagaya po ng nangyayari ngayon, ay dinidispense naman po yung cooling off period at yung strike ban period lamang po ang ino-observe. So, both po yun sa interest ng buong public, ng buong clients po natin ang siniservisyohan. Dahil alam po natin na ang pagkakaroon ng strike would be detrimental not only to the employees involved but also to the business na alam naman po natin dapat magpatuloy to have the Philippines in a place for investment and business.
Thank you very much. We would like to recognize Representative Romeo Acop, Second District, Bacolod City. Can we hear from NAPSI, Mr. Edwin Bustillos?
Thank you, Mr. Chair. I'm Edwin Bustillos from the National Anti-Poverty Commission, former labor and migrant workers. Let me get straight to the point, Mr. Chair. First, we would like to manifest that a strike is not a criminal act. That's the first point. Henceforth, we would like to support House Bill 7043 in its entirety. But let me testify, Mr. Chair, regarding the section where instead of a termination, the penalty should be lower, probably disciplinary action like suspension. to recall, Mr. Chair, please, I would like to stress that in GR 165576, it's a Supreme Court ruling of the Third Division under Justice Natura. The Supreme Court justices mentioned that termination is too harsh a penalty. In fact, I was the union president of Samahan ng mga Manggagawa sa Hayat at the time. We conducted a strike. They said that our strike is illegal, but upon the wisdom of the Supreme Court justices mentioned that 6 months suspension is too harsh a penalty. They even reduced it, Mr. Chair, ng 2 months. No, it's in the record. So hindi po pwede na i-terminate po kagad yung mga officers na in good faith nag-conduct ng strike because of union busting or other ULP acts committed by the employer. No? Second po, klaro din po dun sa desisyon ng Supreme Court na yung pong mga grounds for strike like CBA deadlock, particularly economic provision, massive violation ng economic provision, and ULP ay ano naman po, no? Nasa intention naman po ng trade unions to survive. Kaya po yung kanilang act to go on strike ay protected din naman po as mentioned by Deputy Speaker Mendoza. And lastly po, we would also support the cooling off period as mentioned by TUCP. I think with due respect, the National Conciliation Mediation Board is doing their best naman in conducting preliminary hearings and conciliation mediations, particularly on CBA deadlocks and even ULP. But of course, if there is union busting, definitely the cooling off period should be waived kasi napaka-imposible po na tinanggal na yung mga union officers like what we have in Hayat, Regency Manila at that time, tinanggal na, dadaan pa kami ng cooling off period. So I think, Mr. Chair, yung pong proposal is in order. There is a basis decided by the Supreme Court na ang penalty po can be reduced actually ng 2 months lamang instead of 6 months as decided by the NLRC Commission then. So, we respectfully submit, Mr. Chair.
Thank you.
Mr. Chair, may I make a comment? I agree that joining a strike is not a violation of existing laws. But what is stipulated in this Article 264, it talks about here knowingly participates in an illegal strike. So very clear, it's an illegal act. Ngayon, kung strike lang, alisin natin yung illegal, pwede pa yun. Pero yung sabihin mong illegal strike, and you participate knowingly, mukhang problema yun by definition. Tapos, dito rin, any officer who knowingly participates in the commission of illegal acts, maliwanag, illegal ang ginagawa. Kailangan, kung ano natin, kung pwede, para hindi tayo magkaano dito, kasi illegal nga yan eh. Illegal nga yung act at saka yung strike. Ngayon, I agree na yung strike by itself is not a violation of any constitutional or even any legislative or any law for that matter. Strike lang eh. Pero ito, maliwanag dito sa Section 64. Unless Congressman or the DS baka, kasi maliwanag illegal eh. Kung illegal yan, talagang bawal. Yun ang addressin natin, hindi yung that's what we have to address. Alam mo, illegal, gagawin mo, talagang violation yan. Ngayon sinasabi nyo, wala silang minsan choice, kaya ginagawa nila yun. Yun ang problema, hindi yung penalty, kasi it's very clear that when it is illegal, it's violative of existing law.
Thank you very
Legal
much.
right.
Mr. Chair,
Thank you.
I fully agree with Congressman Go and para maklaro na tayo. The right to strike and to engage in a peaceful activity is a constitutional right. One of the few constitutions in the world tayo na nasa constitution yan. Other constitutions wala. I think the US wala yan. But then again, I'd like to bring to your attention my second paragraph of my amendment. Yung sinasabi lang na any worker or union officer na sinasabi mo na knowingly or lawyers participate in a commission of illegal acts during a strike shall be subjected to due process, which is correct. Due process, agree tayo dyan, under that sentence. And of course, under the jurisdiction of regular courts because these are no illegal acts. Agree tayo dyan, sir? No. Over criminal action, so penal code, ito yun na labor code. So this addresses yung concern natin sa the first paragraph. Kasi one, jurisdiction, regular courts. Two, penal actions na the penal code of the Philippines, di ba? Nandun na yan eh. And of course, but subject to the required clearance from DOLE because it was done under a strike or any activity under the labor code. By the way, the labor code is, TUCP was the one who helped pass it way back in 1989. It's 25 years old na. So, labor laws are very progressive, so it's a living document. And sometime we shall amend it to bring it to better times. Mr. Chair.
Thank you very much. Do we have a motion?
Mr. Chair, I would like to ask ulit, Mr. Joselito Stares, ano po yung tingin yung position dito sa removing dismissal or loss of employment status and imprisonment? Tapos ano yung mga examples sa ibaw? Kasi parang ang gets ko sa sinasabi ni Congressman ko ay illegal strikes, pag illegal strikes, ganun ba sa ground? Baka naman, ano yung actual itsura nung sinasabi ng illegal strike pagdating doon sa mga workers natin, sa mga unions, sa mga federations, Mr. Chair?
Yes?
Okay. Sa grounds po ang actual na nangyayari, kapag ka nag-file ng notice of strike ang union at nagsagawa ng mga concerted action, meron na pong strict violation na ipinapile ang management o ginagawa ang management para i-declare para mag-declare ng strikes legal. Sa mga ganun pa lang na sitwasyon, ay meron ng concerted action. Pagka nagsagawa ng concerted action, meron na kaagad na ginagawa yung management para sumilip o makasilip ng iba't ibang mga grounds para i-declare yung gagawin o hindi pa nga nag-strike, meron na silang mga pinapile na illegal concerted action. So ibig sabihin, doon napipigilan na yung mga manggagawa na magsagawa ng iba't ibang mga aksyon. Kaya doon sa illegal concerted action pa lang, meron nang tinatanggalin yung management eh. So anong gagawin ng union? Ang gagawin ng union, siyempre, talagang mag-i-strike na. Halimbawa, tinanggal na yung mga opisyalis ng union. So ang gagawin talaga nila, mag-i-strike na sila. So doon nawawala yung sinasabi nating right to strike. Parang hindi namin makita ron yung karapatan talaga ng mga manggagawa na magwelga. Hindi namin makita. O talagang inaalis talaga ng management kahit na ng Department of Labor yung karapatan ng mga manggagawang mag-strike. Sabi nga natin, magandang salita yung right to strike pero hindi siya sa ground, hindi siya ganon kaabsolutong pinakikinabangan ng union o ng mga manggagawa dahil laging kasunod doon yung aksyon na mayroong illegal action kaagad na ginawa. Kahit na mga simpleng mga mass action lang ay meron ng illegal action na ginagawa yung mga manggagawa. So, pagka nag-strike ka, dahil doon sa mga ginawa mo previously na mga illegal acts, so sa kanila illegal acts yung magsagawa ka lang ng picket sa labas, kahit na hindi yan during working hours, magsasagawa ka lang ng picket, maglalagay ka ng mga placards. So mga illegal acts na yon. Mga illegal action na yon. So yan, gagamitin na ng management yan bilang illegal action na pagdating na nag-file ka ng pagka nagkaroon ka na naglunsad ka na ng strike, iyan na yung mga gagamitin nilang mga pulatilya para gawing illegal o para maging illegal yung strike ng mga manggagawa. So, mahirap yung dinaranas ng mga manggagawa sa grounds pagka sa ganyang panahon na nagsasagawa ng mga activities yung union, siyempre para ipaliwanag mo sa mga manggagawa, ganito yung sitwasyon, ganito yung kondisyon, walang nangyayari sa mga conciliation na ginagawa sa Department of Labor. So kailangan ipaliwanag mo yon sa mga manggagawa. Pero sa mga panahon yan, meron ng mga illegal acts na nasisilip yung management para kapag nag-huelga ka, isasama lahat yan para maging illegal yung strike. So,
Mr. Chair, first point,
Mr. Chair.
Thank you very much. Can we recognize Representative Rosas?
Mr. Chair, tapos ko lang yung intervention sa kanya. Thank you, Mr. Chair. Mr. Chair, first yung tanong ko, yung sa removing dismissal or loss of employment status, yung Section 3, yung pagtanggal sa Section 3, will it help yung mga manggagawa?
Makakatulong pagka yun ay nilagay. Dahil siyempre, malaking tulong sa mga manggagawa yan pagka yan yung nailagay sa amendments. Dahil magkakaroon ng rooms yung mga manggagawa o yung officers ng union na tinanggal sa panahong nandyan pa yung usapin, na pinag-uusapan pa yung halimbawa CBA deadlock o yung tanggalan, yung o kaya yung sinasabi nating unfair labor practice. So,
Okay. Second, Mr. Chair, makakatulong kung yung Section 3, yung gusto nyo yun. Yung second po, ang tanong ko ay yung sa cooling off period. Halimbawa, bakit yung halimbawa nito, yung halimbawa naka-CBA deadlock, bakit iniisip nyo at ayaw nyo ng cooling off period dito sa mga instances na to?
dito sa panahon kasi ng cooling off period, maraming mga activities na ginagawa ang union at marami ring activities na ginagawa ang management. So, sa panahon na may mga conciliation, may mga karanasan kami dito na ginagapang ng management yung ibang mga officers ng union o nagsasagawa siya ng mga activities na against doon sa ginagawa ng union, sa activities na ginagawa ng union. Halimbawa, yung mga paliwanag sa development ng mga conciliation, yung mga paliwanag yan, ang ginagawa nila diyan hindi o sinasalungat mismo ng management yung tamang dapat na maging ipo-forward na activity result ng mga conciliation doon sa mga manggagawa. So, may mga pagpigil pa. Halimbawa, gusto nating magsagawa ng mga meeting, halimbawa mga officers meeting o mga chief meeting o kaya may mga general membership meeting, may mga restriction na hindi nagagawa ng management yung kanila ng union, yung kanilang kanilang kalayaan para ipahayag yung mga saloobin ng mga manggagawa. So, yun yung isang dahilan din kung bakit yung cooling off period na napakahaba na sabi nga natin 30 days, maraming ginagawa yung management, maraming panggagapang na ginagawa yung management yan para pahubahin, pahinain yung bargaining power ng union at saka ng mga manggagawa.
Thank you, Mr. Chair. Mr. Chair, kasi yung tanong ni Congressman Go on knowingly, di ba? Mr. Chair, parang dito ako nagkakaproblema eh. Regardless of intent, hindi dapat maging equivalent to dismissal siya, Mr. Chair. Parang ganun yung gusto kong point. Kasi maraming ways, katulad ng sinasabi ni Mr. Lito Stares, maraming ways kung paano talaga ginagawa ng management na maging illegal yung isang legal strike supposedly, Mr. Chair. Yan lang naman yung point.
Pwede ba sagutin yung meron namang dito merong under Article 263, nakadefine dito yung proseso. Nakalagay dito, in case of bargaining deadlocks, the duly certified or recognized bargaining agent may file a notice of strike or the employer may file a notice of lockout within the Ministry of Labor 30 days before the intended date thereof. Merong merong batayan kung bakit nakalagay itong provision na ito. Hindi naman basta naisip ko ngayon, bukas mag-strike ka na. Hindi naman pwede yung gano'n. O kaya ikaw ang kumpanya, bukas mag-lockout ka. Diba? At kasama rin dito, kaakibat dito, in some cases, merong cooling off period to give way to settlement of issues between the employer as well as the employee. Yun ang objective. Ngayon, ito lang ang natin. Kasi ang premise na nakikita ko dito, parang ako, galing ako sa management when I was in the private sector. No, pero hindi adversarial. Kasi ang premise dito, parang adversarial. Yung manggagawa, kalaban niya yung kanyang employer. Parang yung nakikita ko dito. Pero kasi looking at from a win-win solution. I don't like employees to be terminated without due process, procedural and substantive due process. Kaya dito, pero pag sinabi mong illegal acts na maliwanag dito, talaga yung bawal. But it should be established that it is illegal. Pag hindi naman na-establish yan, the employer has no right or authority to terminate even under this provision. So merong requirement Pero sinabi natin dito sa batas na illegal nga yan. Pag illegal talagang bawal.
Thank you.
Yun ang natin. Mr. Chair, just last point, yung pangatlo dito, pwede natin siguro amendahan yung provision na, kasi you want to strengthen the right to strike. Okay yun. But we need to consider also the other side of the equation. No? Yung ganon, you strengthen it, but balance din ito sa part ng employers ito. Kailangan sumunod. You have all the rights to the right to strike, but you have to exercise it within the bounds of existing law. Ito nga dito. Yun lang naman ang natin Kasi yung anytime you want to go on strike, okay yun. And if you don't have any penalty as provided under Section 263 and 264, baka everybody just do the same and it will affect the entire business and the country in general. Yun lang ang concern natin dito. Mr. Chair, thank you.
Thank you very much. Do we have a motion to approve? We move for the dispensation. Was there a motion to dispense with the calling of the